Okay, let's get started with the Planning Commission meeting. Do I have a motion to approve the agenda?
So moved.
Second,
Call the roll?
Commissioner Newton,
Yes.
Commissioner Patrick,
Yes.
Commissioner Burke,
No.
Commissioner Bennett,
Yes.
Commissioner Kerr,
yes,
Commissioner Knopf,
Yes.
Chair Johnson.
Yes. Are there any amendments to the meetings from the October meeting? Okay, if not, do I have a motion to approve the meetings? The minutes?
Second.
Call the roll?
Commissioner Bennett, Commissioner Bennett,
Yes.
Commissioner Kerr,
yes,
Commissioner Knopf,
Yes.
Commissioner Newton,
Yes.
Commissioner Patrick,
Yes.
Commissioner Burke,
Yes.
Chair Johnson.
Yes. This is a continuation of the legislative hearing regarding the ZO 21-02. City of Cannon Beach is requesting subdivision and zoning ordinance text amendments. The proposed amendments revise language restricting lot combination, limiting single-family residential dwelling size, and further restrictions to lot coverage and floor area ratio for all residential districts, while repealing planning development language. The request will be reviewed under the Cannon Beach Municipal Code 17.86.072 amendment criteria. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any member believe he or she has a conflict of interest or personal bias? Has any member made an ex parte contact or made a site visit? Okay, is there a staff report?
Yes. First off, I want to thank everyone for bearing with us through the technical difficulties of the last planning commission meeting. And hopefully we're not having any presentation. So hopefully that was maybe part of that issue. IT looked into it and he also felt the Zoom was hadn't been updated in a bit. So he updated that. So we're keeping our fingers crossed, but I want to thank everyone for that. And I also want to thank all the public who have been very civil through all of this, and even the off and on with the technical issues and with the controversial issues that are going on. So on the staff report portion, the only thing I really wanted to touch on was, of course, I had added the you had asked for me to bring back language to kind of make that pre-existing and non-conforming come into agreement. I did that. So to clarify, and I think we've had some public testimony recently about that, also saying, hey, if my structure burnt down, why couldn't I build it back? This is the language I've kind of made them agree. And so in either a pre-existing use or non-conforming structure, if that structure were to burn down, they could either A, build back to the specifications that prior built structure was, or they could choose to build to the newer zoning code. So hopefully I cleared that up with that proposal. Second, it's been discussed, why was 3,500 picked? If you look back at the record, in July, back in the work session, staff had suggested through the different options, the option that was offered was a scaling that started at 5,000 square foot cap for the larger like RVL districts and RL districts, that scaled down to around, I think it was The lowest it went was 3,000, and that was for the R1, R2, and R3 districts. You guys offered 3,500 as kind of a point of agreement. So I just wanted to clarify, that's how that number had been reached. And not to say you guys couldn't change that number or request an amendment to that. So any questions of me? That's really all I had. We also did have a request to speak from Jan when you get to the public testimony.
Oh, okay.
I have a question.
Go ahead,
Ooh,
Lisa, go ahead.
oh, okay, I have a couple of things. The first one is, I think that where it says conform to the setbacks, building heights and floor area, I think we have to make sure, do we define that? Do we mean gross floor area? I think we have to be as specific as possible. So when it says the construction or reconstruction of the structure shall A, conform to the setbacks, building height and floor area of the structure prior to damage. Do you mean gross floor area?
We're just saying to those specifications that building that was already previously there, I don't know how they would alter that gross floor area wise, unless of course they built a basement or some sort, but I don't know how they would sidestep that.
Well, I mean, I just think that you have to be really specific and be, people, I mean, there's way, so we don't end up in a big turmoil again, with somebody before us who arguing that it doesn't specify what we mean by floor area. So I think it's really important to be as specific as possible. And then the
So-
other thing,
Yeah, so I would just suggest, Lisa, just to, if you make a recommendation, just put that state to add gross in there, okay?
okay. And then the other suggestion is what I'm concerned about is where it says 80% of its fair market value is indicated by the records. Is that fair market value of the building only, or does it include the land?
Yeah, it's just the structure, the
I
improvement.
think we have to say that. Fair market value of the building or of the structure, because again, I just, seeing what happens when we're not specific and how convoluted things can get. And I'm just, and I think it should say limited to the total gross floor area of the pre-existing building. I guess that's the same thing as saying structure prior to damage. So yeah, I guess that doesn't really need to be there. I'm just trying to make this so that there's no problems later on. And so just adding the language of the building, not including the land, or what-
Yeah,
yeah.
okay.
And that's actually to the benefit of the person who's rebuilding. I mean, it really is. Because if it, it's to their benefit. And I noticed we got a letter in this last packet from someone, again, concerned about, if their house burned down, what they'd be able to do. And I don't know if they read this proposal or not, because it seemed like they hadn't read the new language, because I think it's pretty clear with a couple little twists to it, little, additions.
Right.
No, Lisa, the only thing I'd add to that, and I may have missed this, but I remember that same letter standing out to me. My takeaway from that letter was that if you have an existing house that burns down and it does not currently comply with the setbacks, that they may not be able to put it back there. So, and again, I was just looking to see if there was some sort of language to talk about it being able to be replaced as it was. Without the setbacks, it doesn't look like the way it's written it is. It has to conform to the new setbacks. Jeff, am I wrong about that?
No, Clay, yes, this gives you two versions where you can conform to the setbacks, building item and gross floor area of the structure prior to the damage or destruction. Or,
Okay, that's the set.
yeah, okay?
Yeah, I think that's really clear.
I agree.
Okay. Well, I'll go ahead and read through this. The pertinent criteria to be considered are noted in the staff report listed on the criteria sheet on the meeting page of the city website. Testimony, argument, and evidence must be directed towards that criteria or other criteria in the comprehensive plan or municipal code which the person testifying believes to apply to the decision. Failure to raise an issue accompanied by statement and evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes the appeal based on that issue. Is there anything else in this that you would like to address? Because I think it's pretty concise. And of course, we've been dealing with it for a while, so I'm not sure if you have additional questions for
Yeah,
Jeff. Go ahead. What?
just fair market value of the building and what kind of floor area you're referring to, so that that's clear and there's never a problem later on. In other words, instead of, someone saying habitable floor area or whatever, just gross floor area. If that's what you mean.
Right.
And so would that also need to be the word gross be put in the non-conforming structure?
Yeah, we'll put it in both of them. We'll make them mirror each other. Thanks, Barb. Yeah.
Okay. So are we going to be bringing this back or no?
No, this is, so you have, you can take public testimony. We had one request from Jan Siebert-Warman, but that's all we received. But no, then you guys can recommend to the city council,
Okay.
deliberate, close it and deliberate.
Okay, well, why don't we get Jan on the phone?
Okay. All right, Jan,
Hello, can you
hear
hear
us?
me?
Yes.
Yes.
Okay, I'm Jan Siebert Warmond, and this letter is also from my husband, Wes Warmond, P.O. Box 778, Cannon Beach, Oregon 97110. Dear Planning Commissioners, regarding zoning ordinance 21-02, we support the following. First, the prohibition of combining or recombining parcels and lots in Cannon Beach. Next, the repeal of planned unit developments, PUDs, in Cannon Beach once and for all. Finally, and very importantly, the limiting of floor area ratios, FARs, to only allow a total of 2,000 square feet of all single-family dwellings, including any accessory structures, on lots of 6,499 square feet or less. On lots larger than 6,499 square feet, the total allowed would be 2,500 square feet, including any accessory structures. These smaller home sizes would encourage significantly more trees to be preserved in our community. The village character of Cannon Beach, featured in our comprehensive plan, and the wooded character of Cannon Beach, highlighted in our municipal code tree ordinance, are at stake. Thank you.
You? Is there anyone out there that would like to make some comments on these amendments? Okay, in that case, we'll close the public hearing and move to consideration.
Well, I'd like to say that I agree with Jan Siebert Warman about, I think 3,500 is a humongous house. But I realize that I seem to be in the minority in thinking that. I just think that that's a giant house. I understand that anything smaller than that is going to cause a huge uproar amongst people building homes in Cannon Beach, because it's really not going to affect people who already have homes. It's just going to affect those people coming in now who want to build a new home. And I just think it's too big, but that's my opinion. I think 2,500 makes a lot more sense than 3,500, but that's again, that's just me.
Depends what the FAR is, though. I mean, if it's including a garage, that's going to jack the square footage pretty high and take away from the house. And so I might say 3,500 is more than necessary, but not that much more than necessary to have a house that's kind of typical of what's already here.
3,500 you think is typical?
Well, at one point, garages didn't count against your square footage. So I guess I'm not quite sure why if we ever decided to start changing any of this stuff, frankly. But I thought that the rules we had were pretty effective, except for things like pushing lots together and so forth. But,
Well, I think one of the questions is scale. And, I think we got into a position where we've been back and forth a number of times on how to make the scale on, a 5,000 foot lot fair to a 10,000, and we really couldn't get there. We have these new zone code amendments coming, and we thought, well, maybe this is a good kind of placeholder. That was my takeaway. And so I never looked at this as forever. I just looked at this as maybe let's put this on hold until we figure out a more effective way to deal with this, because a 20 or a 3,500 foot house on a 5,000 foot lot next to two 900 foot houses on either side does look out of place. But if it's on the other side of 101 and sitting on a few acres of land, the scale is not contradicting one of the principles we've said we wanted to protect, which is the village character of the community. So I think as I've thought about this more and I've read more letters on this, I think maybe looking at this in terms of a way to protect the integrity of our community until we figure out a better way to address it across all of the community, because we haven't come up with a good way yet. This was one way to keep a couple more of these really out of place houses from coming in until we did figure that out. So that's been what I've been thinking about lately. Whatever number we come up with, I think we can come up with something that is maybe more equitable when talking about one area of the presidential streets, for example, versus on the other side of 101. But until that time, let's hold off. I hate to use the word moratorium, Bill. I don't know if that's going to get your hackles up or not, but maybe that's something maybe that's one way to make this more palatable for people, is to go, we're just going to stop these huge houses that are out of proportion from the neighboring houses or the lot they're on until we can figure out a better way to address this.
Yeah, I can accept that. I can accept that train of thought as making a lot of sense.
Well,
You know, at our work session with the city council, there was some indication from the city council members that they were satisfied with the 3,500 square foot. So
I heard lower numbers than that. I mean, I didn't come out of that meeting with a clear understanding at all of where they had consent on the size of house. I mean, there really was from, I know I heard 2,500. And we definitely heard 3,500, but I just think this is an issue that maybe needs a lot more specific dive into to get it fair.
And I just want to weigh in quickly. Yeah, this isn't a moratorium. It's basically, we're putting a limit on it, and maybe there might be some adjustments, as we move forward. So, it's not a moratorium as much as, keeping things at a certain size, and, might fine tune it later in the future.
Well, aren't we definitely fine tuning it as we go into well, I guess it's our directive and the city council's directive to fine tune it in that change. But, with qualified professionals in front of us, that we can pose these questions, these challenges we're having, maybe they can guide us to a fair and equitable way to protect the balance of the community in terms of it maintaining that village character, and at the same time putting some teeth in the language.
Is this language also going to affect, from the 3,500 square feet, does that include the garage or not include a garage? Because if we don't encourage people to build a garage, you're going to have a lot more cars on the street.
Yeah, this does, Janet, the language currently that's before you includes garages.
Floor space.
Yes.
So basically, the house would be limited to approximately 3,100 or 3,000 because of the garage.
Yes, roughly.
I think people will opt not to put a garage in.
See,
We like our cars, I don't know.
I think-
I just want to clarify that even if they don't build a garage, they still are required to have 2 parking spaces on their property.
So even if they don't, so in other words, they can't park on the street. If they have 2 parking spaces they have to have the spaces on their property. So if they choose not to build a garage to get more square footage in their living area, I guess that's their choice, but they're still going to have the parking spaces on their property. And I just don't think people will do that. I think people use garages for a variety of reasons, like storage and, keeping their surfing equipment in and all those other kinds of things too. So I think that people, and they care about their cars. So I think they'll still use a garage. And 3,100 square feet's a big house. I mean, it's huge.
Oh, I agree with you that it's huge, but I'd hate to have large houses be built and then have cars sitting out in a driveway when you drive by. I'd rather see people use their garages or encourage them to use their garage.
Yeah, I think they still will. I just, the weather here encourages the use of a garage.
It's connected to the house, yes, maybe.
Well, I think I'd feel better about a 3,500 foot limit if we did have some kind of a plan to address this more equitably. I know I said that before, but I do want to come. Well, I've got another issue with these amendments, but maybe we should finish this piece of the conversation first. Anybody else have any thoughts on that square footage limitation?
We need to remember that we're stopping a lot of the hugeness by not allowing people to put 2 lots together.
Yeah, that's good too. I'm glad we're doing that.
Yeah. I mean, the land is what's rare. There's lots of spruce here.
And I, of course, would still like to see, I guess we're gonna do that, talk about that in the code audit, building height limits on the ocean front, but that's obviously not the discussion right now. I guess that will be a code audit discussion.
Jeff, I want to come back to this pre-existing language. I've read this a couple times and I still have the concern that I think was voiced in one of the letters. Please point me to another page. I'm on page 21 out of 92 in the first of 2 attachments here. This is the background, your summary of the background. Looks like it's about the second paragraph. Pre-existing use means a use existing on June 19, 1979, which was permitted or conditional use in its use zone as indicated by ordinance 79-4 and the land use and zoning map contained therein, but which as the result of a zoning ordinance map or text change is no longer a permitted or conditional use in its zone, or, and I won't read the rest because it's not the part I'm concerned about. Under section 2 there, below section 2 rather, where a structure, comma, such as, sorry, my eyes are not what they used to be. I'm going to increase the size of this thing. Where a structure such as one of the old motels along Hemlock, which existed prior to June 19, 1979, and has been rezoned to R2 medium density residential, and is no longer a permitted use, would be allowed to be rebuilt if it burnt down, as long as it conformed to the setbacks, building height, and floor area ratio of the structure prior to damage or destruction, or to that of the R2 district. I could read that.
So yeah, I would just say, do you have the packet with the suggested changes in it?
Well, I think I'm looking at them and I still don't see that addressed. I mean, down below there, I do, and I still don't, that word prior, I think could be broadly interpreted and not allow an existing use. So let's take either the motel or one of the houses along the ocean. Is it prior to when it burned down? 2, was the house legal did it ever conform to the zoning code? And I think the reason that's important is some of those houses, especially if we put in some of these new size limits, you're not going to be able to rebuild them.
Why not?
Because of the setbacks.
No, but those.
Counselor, Commissioner Newton, I would point you to page 22, and that's the actual language that's going into the code.
All right, let's go through the section you think addresses it.
Okay, and 1782-040 FA, if a non-conforming use gets destroyed or structure gets destroyed or damaged, A says the new structure can be rebuilt conforming to the setbacks, building height, and floor area of the structure prior to the damage or destruction. So that says, you know, you get the same building setbacks, building height, and floor area as a structure prior to the damage or destruction. So whatever the building was before the fire happened, you get that.
Well, I don't read it that way, Bill. I'm going to read it again. I'm going to try real slow to see it that way, but I'm not seeing that language lead to that interpretation.
I don't see how else you can interpret it.
What does that read to you? What do you think that, how do you read it? And see if we can come up with a way to.
Setbacks, building height, and floor area of the structure. Setbacks, building, floor area. My concern is that it would lead someone to interpret that you would be, you would have to conform to another set of setbacks. Let me read it again. Let's go on to any other concern on that. I'm just going to keep noodling on this, but I want to be real careful around that concern that someone brought up. And I've read this a couple times now and just don't.
Yeah, I would contrast.
I'm having a block on it. I'm not seeing it. But.
Yeah, contrast that to B that says, or you can conform to the setbacks, building height, and other requirements of the zone which is located.
Okay, that
So
helps a little bit.
you can build it as it's required now, as it would be as if it was a blank slate. Or you can go back the building that was there before.
And Clay, this is the same language that the county uses too, for their, for permitting people.
You check that, Lisa?
Yeah,
Okay. All right, we'll move on. If you guys are all comfortable with it, it's maybe a mental block for me. I'm having enough trouble just seeing the words, let alone trying to figure out what they mean.
I mean, if there's language that makes you more comfortable we can clarify it, let's clarify it. But that's the intent of 040 FA.
Okay, I'm just gonna let that go.
Okay. So does somebody want to make a motion?
Bill, how,
oh, go
go
ahead.
ahead, Lisa.
No, you go ahead.
How would one make a motion in such a way that this was viewed as something we were going to revisit relative to the square footage in particular?
So as I understand it, Jeff can let me know if I'm wrong, the idea was that this would approve it and send it to the city council for review. And if the planning commission is not comfortable with that, then, the motion would be to continue it and bring it back to the next meeting of the planning commission.
I move that we send it to the city council for review with a couple little tweaks that I mentioned earlier.
Second.
And I'll just note those, Lisa's, for the record. That was to add gross in the gross floor area and to mirror in both language, and fair market value of the structure.
Right.
Okay, so there's a motion and a second. Any further discussion? Okay, call the roll.
Commissioner Patrick,
no,
Commissioner Burt,
No,
Commissioner Bennett,
Yes.
Commissioner Kerr,
Yes.
Commissioner Knopf,
Yes.
Commissioner Newton,
Yes.
Chair Johnson.
Yes. Okay, that moves on to city council then. Okay, this is a continuation of a quasi judicial hearing regarding the continuation and consideration of AA 21-01 Greg Hathaway request on behalf of Jeff and Jennifer Harrison for an appeal of an administrative decision to approve the building development permit. AA 2101, Jeff and Jennifer Harrison appeal of the city's approval to issue a development building permit for 544 North Laurel Street. The property is located at 544 North Laurel Street, tax lot 7,000, map 51019AD, and in a residential medium density zone. The request will be reviewed against municipal code section 17.88.160, review consisting of additional evidence or de novo review and application section of the zoning ordinance. Conditions of approval of city Cannon Beach Preservation Plan Development Subdivision and approved plat. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any commissioner member believe he or she has a conflict of interest or personal bias? Has any commissioner member had an ex parte contact or made a site visit?
I visit.
Site visit.
Site visit. Okay, staff report.
Yeah, I just first want to note that we received an email correspondence from one of the parties this afternoon wanting to respond to some material that was in the staff report addendum. The email arrived well after the deadline for material to be submitted, and allowing additional testimony now would require restarting the whole 777 process. So we've not provided it to you. We recommend that the PC not consider this new email to the extent the person is not satisfied with the Planning Commission's resolution of this matter. The party will have the opportunity to make his points and an appeal to the council if one occurs.
Okay.
And then I also want to remind you guys that this is an appeal. So upon the review, the Planning Commission may affirm, reverse, or modify in whole or part determination or requirement of the decision that is under review. And that's under 1788-19, your decision. And second, I placed that motion in there. Just wanted to remind you that tentative motion, that in case you guys do want to review findings, that you would, I'd suggested that you put a tentative motion and to call back, and I put a suggested time for next Thursday. That's not Thanksgiving Day, but the following Thursday. But if you do, please state that date certain. And then staff would request that if there is particular evidence in the record, findings or exhibits, that you would, like to incorporate into the draft findings, that you would state that so that staff would have that as reference for that draft findings, okay?
Okay. Well, who wants to delve into this?
Jeff, before we start, could you tell me if that second garage was approved in the original plan approved by the city?
No, well, so are you talking about the Harding garage?
Yes.
So the Harding garage was a separate building permit, not part of the plan. It's not part of the plan development application as such. Do you know what I mean? So a building permit comes in after the plan development is approved. And so it comes in, and as I've explained, then that building permit is held against the record that I, have on hand. And so that's how that got approved.
So, it seems to me the heart of this discussion here is the loft in that garage counted as a finished loft. And I'm not sure how everyone else was feeling about it, but it's certainly clear to me that from the pictures that we've seen, that it certainly looks like a finished loft area. So I'm wanting to know how everybody else is feeling about that.
Well, I totally agree with, who's speaking? I couldn't tell. Is that Darrell? Who just said that?
No, it was me, Daryl.
Daryl, yes. I agree with Chairman Daryl on that, because I think that I cannot imagine a storage space or a loft that has beautifully finished and trimmed windows with a view of the ocean, as well as skylights and electrical outlets befitting a residential space, heated floors, evidently. I mean, all that's missing is the ladder leading up to that loft space. And even in their advertisement, when they were advertising their home for sale, they mentioned that space as office space, or potential office space. So I just to call it storage space it seems like almost an insult to the viewer's intelligence. I mean, it's clearly is a finished space. There's no way around it.
Well, yeah, and also, You know, I had a loft when I lived in Portland and it didn't look nearly as nice as this loft. I would say if you put a futon up there, you'd be having a wonderful bedroom space. And obviously there, one of the pictures that was passed around at the time, there was a ladder in the garage. So this idea that you can't get up there seems pretty ridiculous to me. So anyways, that's what I'm thinking.
Yeah, I mean, I don't understand why this wasn't nipped in the bud. Well, I do understand why, because I think that once someone starts to build something, it's much harder to stop them and to go back than to just let them go ahead, especially if they're, you know, if the applicant's extremely persuasive. I think it's easy to get kind of lulled into approving something like this, but I just don't, how that could be approved as not being a finished space. I can't see it. I think it should be counted in the, you know, the floor area ratio. I think it's habitable, and I think it counts as part of the floor area, both. And I think that that means to me that the Nijami, I think that's how you say it, Nijimi application needs to, I think the appeal has merit. And the floor area ratio of the whole thing is too big. It goes over the allowed floor area ratio. And I think it also goes against the conditions of condition 16 of the agreement with the city. So I think in both, you know, I find it really interesting that there's an argument that the appellant is arguing that the requirement of condition 16 does not say you can't build a two more than one garage. It says only they're limiting you to a 2-car garage. And I think that argument just makes no sense to me. I mean, you can't expect a condition to list everything you cannot do. It also does not say you can't build the garage out of Legos, but we all know that, you know, you can't. So you can't expect that the conditions are going to say every possibility of something you cannot do. They keep mentioning it, and they mention it in the singular all throughout that condition. Garage, not garages. Why would they limit it to 2 cars if they were going to allow you to have 2 2-car garages? It makes no sense. So I think that argument holds no water with me. I think you have to have common sense and plain English have to take the, you know, precedence here. And
Lisa,
can't have, oh, go ahead.
I'm sorry to interrupt you. I agree with you both on especially on the common sense side. I think, you know, keeping focused on is it finished space or not is probably very important for us. It's clearly finished. One of the things that has caught my attention, both in our staff's report and for the applicant and from the applicant's attorney from LUBA, that I want us to be very conscientious and aware of, is any perception that we are attempting to frustrate this process. As we talk about these issues, I want to make sure that we've thought about them in the context of what we've already discussed, and being equitable and not looking like we're frustrating the process. And I don't want to be a part of that. So I think, you know, the easy one for me is the garage. That's so clear that this was not intended to be a compound. It was not intended to have a bunch of garages out there. It was not how it was pitched to the city. It was not the conditions that the city had to be in place for this lot. So, you know, there is a garage on there now. How that's worked out for the house, I understand there's a lawsuit going now. our focus has to be on what's written, what has been applied for, what has been appealed. Mr. Harrison is saying this does not conform. He has put that forward in a way to us that was not put forward from him last time. So that's one way this is different than the last time when we discussed this. We have an appeal on this specific item from the neighbor. The issue around effectively the FAR, when we're talking about habitable space or finished space, I agree with the common sense approach, the common sense behind that being finished, and it should be counted. I want to make sure that we really talk about whether that could be seen as us trying to frustrate or being a part of frustrating this process for Mr. Najimi.
I mean, I understand your concern. I'm actually feel very, very objective about this. I mean, the Najimis can cure it if they have to without too much trouble by lowering the amount of I guess, I don't know. It's not really my business how they cure it, or if they cure it. But I'm just saying, I think that just on its face, these elements in the appeal make sense to me. I spent a lot of time reading through it. I mean, I read through it twice, every single thing. And it just seemed to me that the arguments about the FAR made complete sense and the two garages. I just can't, whether or not, I don't know what the end result will be. I don't know how it will affect anybody, to tell you the truth. I don't know if Mr. Harrison and Mrs. Harrison are going to feel vindicated in any way, even if they win this appeal, because, there'll be another application and there still will probably be a house there. So I don't think that's the issue. I think the issue is that at some point in this process, we have to start applying the conditions to this development and applying the ordinances to it. And I think that this is our chance to do that. I mean, I think this has gone on too long.
Well, I can say it's never been more clear to me after looking at the pictures that were submitted as a part of this process that area was finished. I've never put my eyes on the level of finished detail until this process. And the text that has been shown on advertising does lead me to believe it's finished very clearly.
And I don't think also, one of my big concerns is I feel like I want to make sure that I'm not part or agreeing to any decision that is being made under threat of a lawsuit. I don't think that should come into our consideration of anything. And I think that sometimes, I think that the reason this whole PUD got, I think that the council felt threatened by a lawsuit, by all the lawyers that Mr. Nicholson had in front of him. And I think that they made their decision way back when the whole thing was given the go-ahead based on fear of a lawsuit. And I don't think that should have I think we have to do what's right, regardless of that.
Jeff, can I ask what I hope is a constructive question for a path forward? If the garages were taken out of Mr. Najimi's proposal, would his house comply with the FAR as proposed?
Yes, I believe so.
So, Bill?
Yep.
If one of the concerns is that the property does not comply with the FAR, and we say we're not approving this permit because it's too large and it has too many garages, would we effectively be addressing some of the concerns by saying the permit is not approved? Would we be providing a clear path or a path that is not seen as being, what's the word I've been looking for here? Frustrating this process. If we said, take the garage out and you will apply to our FAR, and that would be a building permit that we would approve. But as submitted, it does not apply to our FAR, and you have too many garages on the site.
You know, what I don't want to do is say, if you do X, Y, and Z, we're going to approve it. You know, you want to find a clear path. And the way you do that is saying, this is what's wrong and that's what's wrong. And it sounds like, you know, the planning commission has concerns about going over the FAR and that there's too many, you know, that you get one garage. And if we make that clear, that provides that path, and we don't have to say, you know, be quite that explicit.
Okay, thank you.
So you know, the question really is more, you know, assuming the planning commission makes this decision, I would assume whoever doesn't prevail here will appeal it on to the city council and possibly LUBA. And, you know, what we don't know is where those two bodies will end up on it. And, you know, we'll see where that goes. But if that's a decision of the planning commission, we can write up those findings, and, you know, we'll make that, you know, do the best, defend the will of the planning commission as best we can.
I think that's an excellent suggestion. The FAR is too large and not a second garage on the property.
Is that a motion, Jen?
Oh, well, I guess I can put it in to a motion that, you know, I'll let Bill write it so that it's legally correct.
Just put the word tentative in, and I think we're good.
Yes, thank you.
Okay, is somebody making a motion?
So I would suggest looking at what's this page. You know, Jeff actually wrote one out for you. And Jeff, do you have the page number on the packet? 'Cause it's going to take me a second to get there. Yeah, here it is, page 38 of the packet. And I can state it for the commission and see, you know, having considered the evidence in the record, I move to tentatively reverse the I move to tentatively deny the application and reverse the decision of the planning director in the Jeff and Jennifer Harrison appeal of administrative decision approving development permit for 544 Laurel Street, tax lot 5109 8007,000, Cannon Beach Planning Commission application AA 2101, as discussed this evening regarding the FAR and the number of garages, and request staff to draft findings for review and adoption at a special called meeting next Thursday at 6 p.m., December 2nd at City Hall.
Is that your motion, Jan?
Yeah, definitely. That's it.
And just to clarify, is that date okay with everyone?
Yeah, but strike the word next.
Yeah, on
Not
December
next.
2nd.
Yep.
Thank you.
December 7th is the meeting.
Second.
I second Jan's motion.
I'm sorry, who made the motion?
Jan,
Jan?
Okay, is there a second?
I second it.
Okay. Call the roll?
Commissioner Kerr,
Yes.
Commissioner Knopf,
Yes.
Commissioner Newton,
Yes.
Commissioner Patrick,
Yes.
Commissioner Burke,
Yes.
Commissioner Bennett,
Yes.
Mayor Johnson,
Yes. All right. This is quasi judicial hearing regarding the public hearing and consideration of AA 21-02 Haystack Rock LLC request for appeal of administrative decision to approve a development permit. AA 21-02 Haystack Rock LLC appeal of the city administrative decision to approve development permit DP 21-20 for tax lot 51031 AA 00600 for stabilization pinning of a geological hazardous area. The property is a vacated lot located north of Nianana Avenue. tax lot 600, map 51031AA, and is in a residential low density zone. The appeal will be reviewed pursuant to municipal code section 17.92.0 development permit, section 17.62 grading, erosion and sedimentation control, section 17.50 development requirement for potential geological hazard area, and section 17.88180 review consisting of additional evidence for de novo review and application section of the zoning ordinance. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Does any member believe he or she has conflict of interest or personal bias? Has any commissioner member had an ex parte contact or made site visit?
Site visit.
Site visit.
Site visit. Okay, staff report.
Okay, before I begin the staff report, I also want to say that we had a request after we received afternoon requesting a continuance of this by Mr. Rasmussen. And Bill's written me that he'd suggest that the commission upon hearing suggest that the commission open the hearing and take whatever testimony people want to offer tonight, then close the hearing, and the planning commission is required to grant some type of extension. The planning commission can either one, continue the matter to the next meeting and hold another hearing, or two, allow additional written testimony through the 777 process, as we've done in the past. Given our proximity to Thanksgiving, the PC could provide additional time for people to submit, for example, 14-14-7. But he noted that keep in mind the other holidays coming up and the 120-day rule.
How far are we on the 120-day rule?
Let's see, I think that is in the planning, the staff report here. So let me pull it up. It will be 120 days from when we received the application. So let's see, it's right there. So I can get that for you. I don't have it immediately. Let me touch on the staff report real quick, and then I can look into that while you're accepting public comment. So just to briefly discuss the staff comments on the staff report. The first arguments were regarding processing this all in one application with the house, the stability beam permit. We do have a criteria in our zoning ordinance that allows property owners to combine, but there's nothing in our zoning code that requires them to combine. So they may want to combine them, and we will, you guys, and we can grant that, but for us to separate them, that's not one of the things in our code. And then also discusses the requirement about these Mr. Rondema and the stability beam separated from the house. And on a further note, Mr. Rondema, the geotech, specifically states, and I put that statement in the staff report, that they are separate. And indeed, if the what is the smaller house to the oceanfront setback is approved, it would be separate from that, just from the site plans that are submitted, that alternative plans, as you can see. And then the applicant argues that the appellant has argued that the applicant has not met the zoning and building requirements, arguing that the city's wetlands overlay and stream corridor or language should address this. But if you look at our code, it's not a wetland lot of record. First off, as you can see from the figure presented, it may have wet areas, but I don't know any lot in Cannon Beach that's not wet at times. But it's not a wetland. And that's a very different jurisdictional determination. It's made by a wetland specialist who comes on site and makes that decision. And then all of those permitting requirements that the appellant has asked or discussed falls from that. So if it is a jurisdictional wetland, that jurisdictional wetland is delineated. There's a 5-foot buffer. Anything within that, then we would require extra permitting, but this is not within that area. And so let's see. Furthermore, I just wanted to highlight in the conditions that tree removal, the right-of-way permit, all of that is mentioned also in the conditions that were conditionally approved as part of that development permit. And so, like I said, Mr. Rasmussen would like this to be continued. And then, did we get any asking for public testimony?
We did not, but I looked at the 180 days, it'll be April 3rd.
April 3rd, okay.
Okay, the pertinent criteria to be considered are noted in the staff report and listed on the criteria sheet on the meeting page of the city website. Testimony, argument, and evidence must be directed towards those criteria or other criteria in the comprehensive plan or municipal code which the person testifying believes to apply to the decision. Failure to raise an issue accompanied by statement or evidence sufficient to afford the decision makers and the parties the opportunity to respond to the issue precludes the appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, argument, and evidence regarding the application. The Planning Commission shall grant such a request by continuing the public hearing and leaving the record open for additional written testimony, argument, and evidence. Persons who testify shall be recognized by the chairman, state their full name and mailing address, and if appearing in a representative capacity, identify who you represent. Is there a presentation by the applicant?
Will Rasmussen here. I'm the appellant. I assume you wanted me to go.
I think the applicant, as the party that bears the burden of persuasion, on appeal, is probably the party that goes first and last, and that would be Mr. Wilson.
That's fine with me as long as I get to go in the middle.
Yeah.
Okay. Thank you. Good evening, everybody. My name is Fred Wilson. I'm with the Kellington Law Group. Our address is P.O. Box 159, Lake Oswego, Oregon 97034. We represent Stan and Rebecca Roberts, who are the applicants in this case. First of all, I'd like to thank the planning staff and Mr. Adams for the staff report. It's very thorough. It hit everything that had to be hit, so we appreciate that. Sort of the background, there's a lot of moving parts to the sort of all the proposed development regarding the Roberts property. I think everyone probably already knows that they wanted to build about a 2,700 square foot house. I'm just going to call that the regular sized house. That got denied by the city, got appealed to LUBA. LUBA affirmed the city. It's now up at the Court of Appeals, waiting for a decision there. As it's a distinct possibility that the Roberts won't be able to build that house, they've sort of moved on to potential plan B, which would be to build a much smaller house, almost like a tiny house that does meet the required setback that the city has. And they've submitted a number of applications to go with that. There's the development permit for the actual house. There is a driveway permit, and there was also the stability beam permit, which is the one that's issued tonight. that is, as Mr. Adams discussed, that's been separated from the other two permits for the development permit and for the driveway permit. So a lot of the arguments that have been made have to do with the driveway permit or the house itself and not the stability beam. It might be helpful for me to explain exactly what's going on with the stability beam, because I think there's been some confusion and some people think it's some sort of Trojan horse to get approval for the house itself. If the Roberts do get a favorable decision to Court of Appeals and get to build the regular size house, then they would likely tie that house into the stability beam because it would support both the lot and the house. As that might very well not happen. If they build the tiny house, at first they thought maybe the patio of the tiny house would tie into the stability beam, but after discussions with the architect and the geotech person, turns out it wouldn't. The stability beam would be west of any part of the house or patio or anything, so it'd be completely separate. And then there's also the possibility, since there's so much opposition to them doing anything with the property, that they might not be able to do anything. In that case, the stability beam would at least preserve the property, help preserve the property in a safer state in case something in the future gets built. So it's not some sort of sneaky way to get the house approved. And there's even the first condition of approval makes crystal clear that approving the stability beam does nothing to get the house, any sort of house approved. So I just wanted to clear that up. So this is actually a really pretty straightforward case. That's one of the reasons we separated it. The only real criteria, as Mr. Adams talked about, are the geologic hazard area criteria of 17.50.040 and 17.62 for the grading and erosion. And so for the geologic hazard area, required to have a geologic site investigation report, and in this case, an engineering report. Those were both provided. The experts have to determine that the construction methods will minimize the hazard to an acceptable level. They found that. Staff agreed with that. There isn't any opposition or anybody trying to rebut the experts' testimony, as far as I'm aware of. So those criteria met, and that's sort of the end of discussion for the geologic hazard area criteria. The other criteria for the grading and erosion permit, there are sort of informational requirements for that. Those were provided. There are some technical standards. Those were provided. Staff agreed. Those were met. The opponents don't challenge those. So I think that's sort of the end of the story for there. That one's satisfied too. And that's actually the only things that have to be approved for the stability beam to go forward. So it makes it a very simple case for y'all. The opponents have raised some other issues, and Mr. Adams covered it very well, and we covered it in our letter, so I don't want to go over it in tremendous detail. But they basically raised arguments that aren't really relevant to those approval criteria. One was that the applications all have to be combined. As Mr. Adams explained, they don't. We could have if we wanted to, but we didn't. One, because this is so straightforward, and also there's so much opposition to any sort of house whatsoever. It made sense to go forward with this and hope to get it in sooner. They said we didn't address all the relevant standards, like the stream corridor protections, the oceanfront management overlay zone, and the wetlands. And again, as Mr. Adams explained, those just don't apply to the property. They also said we needed to get state and federal permits. Don't think we need to get the ones they talked about, but even if we did, we'd just go through the state and federal processing permit processing procedures. And if we have to do that, we'll do that, but they aren't approval criteria for this case. They said we needed to get, there were problems with our driveway permit, and that would stop putting in the stability beam. It's a little confusing because there's so many moving parts to this, and there was completeness letters sent that sort of overlapped, but the basic response is we actually don't need a driveway. We don't have to put in a driveway to put in the stability beam. All we need to do is we'd have to remove the guardrail and go down, but then we could use the existing, what's left of the old driveway was there for the old house that used to be there. Wouldn't have to remove any trees and could put it in. So we don't need a new driveway, whether it be a normal kind of driveway or the flying driveway that some people are upset about, which so any of those arguments that the opponents make regarding whether we should or should not get our driveway permit, there'll be a time and place to argue about those, but that's not really relevant for the stability beam case. And also for the last argument about needing specific city council approval to use a street or to use a staging area on Inspiration Point. Again, if that comes up regarding the driveway, or if that's needed to build a house at some point in the future, those arguments might become relevant and we can argue about them then. But don't need a new driveway, don't need a staging point to put in the stability beam. So none of those are really applicable for this. One final thing I wanted to talk about a little bit was at the end of the staff report, it talks about some completeness letters and alternative building plans and needing a right-of-way permit that matches that. And Mr. Adams, correct me if I'm wrong, but I think those are sort of getting combining some of the other applications we have going for the development permit for the tiny house and for the driveway. None of that is actually necessary for the stability beam case that we have today. All that would need to put in the stability beam would be a right-of-way permit. We had one earlier, but they only last 60 days and it's too late in the season and too wet now to do it. So we would come back in the spring or summer when it gets put in and get another right-of-way permit. If necessary, there could be a condition of approval for that. But I don't think there's anything in the approval criteria that require that. But if we wanted to do it, that's what we do. I think with that hits all the things I wanted to talk about. Again, I think Mr. Adams covered everything really well. If you have any questions, I'd be happy to answer anything.
I have a question.
Yes.
Why do you, I understand that the second application for a house is somewhere in the neighborhood of 1,300 square feet?
Yeah, I think that's in the neighborhood, yeah.
Well, why do you keep calling it a tiny house? Because the International Residential Code, a tiny house is 400 to 600 square feet, and a small house is 600 to 1,000. This is neither a tiny house nor a small house. So I feel like the constant reference to a tiny house is just, it's for effect, and it isn't really accurate.
I'm sorry, that's how it was referenced in our application, but you make an excellent point. I should probably call it the smaller house.
Okay, thanks.
Mr. Wilson, has there been a conversation about what sort of right-of-way permits you would need if the Roberts were developing or the right-of-way was being developed or the driveway was being developed? What sort of right-of-way permits would be needed for those actions?
For the driveway?
For example, yes, the driveway.
Yeah, I'm not sure I can completely answer that right now because those applications, I think even this week, there's been a lot of paper going back and forth trying to get those applications complete. And so I would probably have to have our engineers come in and talk about that.
Okay.
But for the stability beam permit, for the stability beam itself, all we would need is a standard right-of-way permit, just remove the guardrail and use the existing driveway.
Thank you.
Okay, are there any other presentations by proponents? Okay.
I don't know I'm sorry, I know there's been a request to continue the hearing. Do you want our input on that now or wait till the end of the hearing, Mr. Wiseman, or?
No, this is going to be continued, but I'm just speaking for tonight. Are there anybody else that are making presentations for the proponents?
And I think Mr. Wilson was just indicating that he understands it's going to be continued, but he might have a perspective of, whether to another hearing, whether 777 or additional time. And I think it might be good to get that out now.
Okay. Yeah, I think I realize it can be one or the other. I think our preference would be that the record would be left open and no need to have another hearing, but that would be our position. And I think if we do the open record period, maybe a little bit longer, at least on the initial period, since it's Thanksgiving. I think that was referenced earlier, so we wouldn't object to that.
So the 777, that would put us, that would give us enough time before our next meeting?
1477, I think, well, 777 would. 1477, I think that puts us, what, 2 days shy of the next meeting? Or how's that work, Katie?
Ours is early next month too.
Right,
so-
21st.
There could be a 10-7-7, give 3 extra days in light of the Thanksgiving holiday, and that would give you, the commission, and, more time to absorb the material instead of just 2 days beforehand.
Yeah, okay, well then, let's do the 10-7-7.
And there might be further input from other testimony, but, tentatively that makes sense, but let's listen if somebody might have a better suggestion. Holidays are always tough.
Yeah. Okay, okay, there are presentations by opponents.
And I think Mr. Rasmussen, as the appellant, would probably be the appropriate person to go next.
Yes.
Thank you, Chair and Bill. Will Rasmussen here from Miller Nash LLP on behalf of appellant Haystack Rock LLC. Address is 111 Southwest 5th Avenue, Portland, Oregon, 97204. Preliminary matter on the continuance. Bill's proposed time frame of 10-7-7-7 sounds fine to me, or 10-7-7, excuse me. But I might suggest that you give the opportunity for brief comments, brief argument, not new evidence at your next hearing. Sometimes, frankly, folks have helpful little tidbits of information after the information is exchanged that might streamline the Planning Commission review. So 10-7-7 sounds fine to me, but I might request an opportunity for maybe 3-minute, 5-minute type argument or comment before you go into deliberation on this.
Okay, I'll just say right now, then we will accept oral arguments, but no longer than 10 minutes.
I can promise you I will not exceed that if I have anything to say, but it can be helpful. Today, I'm going to try to keep it tight for you. I just want to raise 3 points. I think the written materials summarize this well. First, the stability beam is part and parcel of their house and should be treated as such. Second, the application cannot move forward without permission from the city regarding access and staging. And third, the Planning Commission should deny this application or deem it incomplete, I guess deny it for the 2 foregoing reasons. If it were to consider approval, it should make the conditions of approval more robust to reflect the information that's been submitted thus far and to reflect the existence of the oceanfront setback. So first, just regarding the point that the stability beam is part and parcel of the prior house, all of the parties agree that individual components of a structure cannot be approved independently. For example, if you're going to build a house, you can't say I'm going to build these 2 walls under one application, knowing that you're going to come in for a subsequent application for 2 more walls. The Roberts have been clear in these application materials, and Mr. Wilson was clear tonight, that their first plan is to build the prior house. We'll be polite and call it the larger house. The stability beam is located at the exact same location near the western wall of that prior house in the oceanfront setback. That location is solely selected because they want it to be part and parcel of the prior denied house. When they submitted the quote application for a new smaller house, they didn't submit home designs or any new plans or anything like that. They just said, we want a smaller house to kind of continue this farce. The Roberts have told the city, the public, and now even the press that they have no intention of building a smaller house. Today, between noon and 1, I submitted the article that I'm assuming some of the planning commissioners saw from the Daily Astorian from last week, November 15th, written by Katie Frankowitz, that includes some quotes from applicant Stan Roberts. And she reports, and I quote regarding Mr. Roberts, Now he's spent thousands of dollars trying to realize that dream with no guarantee that it will happen. He's angry. Quoting Mr. Roberts, Cannon Beach, I will tell you, should be renamed Cannot Beach. Roberts does not think he will win an appeal at the Court of Appeals. Perhaps he'll take the matter to the Oregon Supreme Court next. He's unsure. This is the part that's important for this particular application. What he is sure about, though, is a feeling that his neighbors have more ownership or say over what happens over property than he does. Roberts is not interested in building a smaller house to satisfy the city's requirements. There is a good chance, he thinks, that he'll never be able to build the house he envisioned. If no is the final answer, he'll put something else on the property. Some kind of homeless shelter, maybe, he said, or, quote, the most obnoxious part. This is relevant for this application because the intent to not build the small house further demonstrates what we've already heard, what we read in the application materials and heard from Mr. Wilson, that the primary purpose of this is try to build a big house and to try to get the stability beam application piece of the big house moving separately from that. I don't think the Planning Commission needs to ignore that fact. I think the Planning Commission can consider the fact that the primary purpose of this application is to build a house that's already been denied in the oceanfront setback. This is an identical application to the 2020 stability beam application that the city found could not move forward apart from an actual home application. They have not severed it from that, and they cannot do so. The city should not reverse course now and allow the stability beam to move forward separately, particularly when applicant has stated that their primary intent is to build the large house. Moving on to my second point, that this application cannot move forward separately from the access.
Well, you're fading out.
Oh, sorry. I'm going to lean forward again. I always have this problem with Cannon Beach. Thank you for letting me know.
Okay.
This application cannot move forward without city council approval first regarding the access and staging. Again, the application materials make clear that they need certain things to happen, certain changes to happen in the unimproved right of way of Nenana. That impacts to land. Municipal Code section 17.92.040A states, and I quote, an application for an action or permit provided by this title shall consist of subpoint 2, proof that the property affected by the application is in the exclusive ownership of the applicant, or that the applicant has the consent of all partners in ownership of the affected properties. This thing affects unimproved Nenana. As a result, the city council needs to give authority before they go in and change things in unimproved Nenana, including what Mr. Wilson referenced with the guardrail and going down the old access, which actually crosses over out of the right of way onto Inspiration Point. Third, my last point, this thing should be denied for those two reasons. If this commission, though, is going to consider moving this forward as staff has proposed, they need to they need to robustly increase the conditions of approval to reflect certain things. First, a condition of approval should be added stating that the stability beam not be completed without city approval regarding the impacts to unimproved Nenana first. Second, that no structure can attach to the stability beam. The city has already decided that the oceanfront setback applies here. By trying to move this application forward first, applicant is trying to have its cake and eat it too. It's trying to get around the city's decision that development above that stability beam is in the oceanfront setback and not allowed. They've said today that they won't attach to it if it's the small house. So the city should at least include a condition of approval saying applicant will not connect a house to that stability beam that's in the oceanfront setback. Thank you to the Planning Commission members and to staff. This is, by my count, and you can count it several different ways, the 7th or 8th application that it's had in front of it regarding this site and this property. I get paid to be here, and the other attorneys working tonight get to be paid to be here, but you guys are volunteering, so thank you for that service.
Okay, are there any other opponents that would like to speak? Okay, staff response?
Well, Bill, should we take the applicants before my response, or?
Yeah, the applicant should be given an opportunity to provide rebuttal, and then we can move on to staff.
Okay.
Okay, does the applicant like to make the last statement?
Yeah, thank you. Again, that's basically the same arguments were made before. Just want to reiterate again that the only way the Roberts would be able to use the stability beam for the larger house would be if the Court of Appeals reverses LUBA and says that the oceanfront setback doesn't apply the way the city says it does. So there's no way that they would be able to build a larger house unless that happens. So to say this is some way to sort of get around that just isn't the case. And I didn't see the Daily Astorian article that Mr. Rasmussen referenced being in the packet today, but I think you can sort of understand why Mr. Roberts would be frustrated. Like you said, there's been lots and lots of applications and lots of money spent. But even if that makes him out to look like a bad guy, which is what I think they were trying to do, that doesn't have anything to do with the approval criteria here. All this is for the stability beam. It doesn't have anything to do with the driveway or a staging point or anything like that. So I think that wraps up our rebuttal. So thank you.
Okay. And so would you like
What's that?
my comments now?
Staff report?
Yeah. So just a couple points. So this will be continued, but just to remind you that, this is a appeal. So you have that same, upon review, the Planning Commission may affirm, reverse, or modify in whole or part. So Mr. Rasmussen suggested more robust conditions. So you can modify in part those conditions. And so he had mentioned no structure can attach to stability beam. Well, I would ask that if that is considered, that it would be no structure can attach to stability beam in the oceanfront setback. So, they can attach to it further back. I don't see where the city would have a problem with that. And so that's why we want to keep these kind of things separate. And so, I think Mr. Rasmussen has suggested the guardrail removal and needed to go before the city council. I would suggest that Bill and I will look at that in the language, because it was my understanding that no, it just needs the public works director. And we are not, once again, looking for the stability beam. As Mr. Wilson said, we're not looking for the complete driveway approval. They are just looking for access, much as our city does when we remove the guardrail to go work on the drainage lines that are down there. So we use that access point, and we use that drive that's been put down there currently, the city does. And so, I want you to keep that in mind. This is not to build a brand new, whether it's the first public road, the private driveway access easement, which is another thing that's before the city council right now. That's not these two things. This is just access to put the stability beam in. And so those are just the points that I wanted to cover, and before we continue this.
So can this stabilizing beam be placed in the oceanfront setback?
Yes, because it's below the 30-inch, and it's supposedly not visible like that. So yeah, it's not a structure.
Okay, well, this is going to be continued to next month on the 10/7/7 timeframe. So with that, let's move on to our next item.
Chair Johnson, before we go, I just want to say those dates out loud and make sure everybody's on the same page. So just so we have, everybody knows the dates. So by my calculation, 10 days from tonight is Friday, December 3rd at 5 p.m. So Friday, December 3rd is the deadline for anybody to submit any and all evidence, arguments, and testimony. Then 7 days is Friday, December 10th at 5 p.m. And that's for anybody to submit rebuttal to new evidence that came in. So the second period is limited to rebutting new evidence that comes in. And then Friday, December 17th is for the applicant and the applicant only to submit final written argument with no evidence. This is what's laid out in ORS 763. And then this matter will be continued and the Planning Commission will hear it further on December 21st. That's Tuesday, December 21st. And I want to go a little further. Chair Johnson, you indicated that you would allow limited written or limited oral argument. Again, no new evidence, no new arguments. And you would limit it to 10 minutes. And I want to make sure, is it 10 minutes total or 10 minutes to each person who provides testimony?
For each person.
Okay.
Can we vote on that?
And we must finish before midnight.
Before Santa comes.
Okay. Okay, is that clear to everyone?
Okay, thank you, Chair Johnson.
Okay, thank you. Okay, moving on to our next item. Public hearing and consideration of SR 21-06, David Veneta request on behalf of John Henry of 1688 South Hemlock for a setback reduction of the rear yard setback requirements for a deck stairs in conjunction with an addition to the existing residence. SR 21-06, David Beneo request on behalf of John Henry for a setback reduction to reduce the rear yard setback from the required 15 feet to 11 and a half to build a new exit stairs onto the reconstructed second floor deck according to Chapter 17.14 residential medium density zone of the municipal code. The property is located at 1688 South Hemlock Street, tax lot 4103, map 5130DA, and in residential medium density zone. The request will be reviewed against municipal code section 17.64.010 setback reduction provisions established. Does anyone object to the Planning Commission to hear this matter at this time? Does any commissioner member believe he or she has a conflict of interest or personal bias? Has any commissioner member had an ex parte contact or made a site visit?
Site visit.
Site visit.
Site visit. Okay, staff report.
All right. David Veneta on behalf of John Henry is seeking a setback reduction of the rear yard setback from 15 feet to 11 feet and 6 inches to allow for a new deck stairs for an existing single-family residence at 1688 South Hemlock. The 5,717 square foot residential medium density zone lot is a through lot access from South Hemlock with a rear yard frontage along Forest Lawn. The 2,882 square foot existing residence, according to Clatsop County Assessor's Office records, was built in 1991. As indicated on the CKI survey, oceanfront setback from the Cannon Beach history by location records. Many of the homes and accessory structures located along this stretch of Forest Lawn are non-conforming structures placed well within the required yards adjacent to the Forest Lawn right-of-way, presumably due to the geologic hazards presented by the sites along the oceanfront. Many of the neighboring properties, including the recently approved Cardwell and Klonoff properties at 1696 South Hemlock and 1658 Forest Lawn, the new home at 1698 Forest Lawn, and the homes at 1680 and 1740 Forest Lawn, have received setback reductions or variances over the past 20 years. So the applicable criteria, I'll just touch on the main points. And under A, total building coverage, it complies. It does not seem to impair any scenic views as it's right directly west of the existing structure, and there's no sight lines from other structures that would be impeded. The same with the solar. We have no verification that it's going to affect it in any way. And then A4, the one point that I do want to bring attention to, the applicant has provided that F, rehabilitation of existing buildings where other reasonable alternatives do not exist, but doesn't speak to any alternatives. Currently, the small existing deck area has only an internal point of access. The proposal would extend this to external access, but other than mention of an improved fire safety access from Forest Lawn, doesn't offer explanation of why it is necessary, and Mr. Veneta can speak to that. And then that's the main points that I'd like to bring up. Any questions?
Is there any additional correspondence?
Not that well, there's quite a few in this, in the record that provided in your packet. And then there were some additional materials, but we haven't received any, Katie, to speak, have we? Yeah.
Nothing that wasn't included.
Oh, okay. Yeah. Okay. The pertinent criteria to be considered are noted in the staff report and listed in the criteria sheet on the meeting page of the city website. Testimony, argument, and evidence must be directed towards that criteria or other criteria in the comprehensive plan or municipal code, which the person testifying believes to apply to the decision. Failure to raise an issue accompanied by statement or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, argument, evidence regarding the application. The Planning Commission shall grant such request by continuing the public hearing and leaving the record open for additional written testimony, argument, and evidence. Persons who testify shall receive recognition by the chair. State your full name and mailing address. If appearing in a representative capacity, identify who they represent. Is there a presentation by the applicant?
Yes, this is David Veneta, Post Office Box 648, Tolovana Park, Oregon 97145. And I represent the Henrys in this setback reduction application. Just wanted to reiterate a couple points Jeff made in his staff report. One of them is that this property is really sandwiched between Forest Lawn and Hemlock. And as I think it's one of maybe 3 properties that front on Hemlock that really would be better served fronting on Forest Lawn. However, they are what they are. And it does bring up the need, though, for the Henrys to access Forest Lawn from their property rather than go completely around from Hemlock or through a side yard to actually get access to Forest Lawn and eventually to access the beach itself. So that's part of the criteria or situation that they are facing, and hence the desire to provide both an access stair as well as a secondary exit stair from their second floor. One of the, I think we received several letters of support from neighbors, and again, as Jeff referred to, there's been a number of setback reductions and setback reduction variances granted along Forest Lawn due to the unique situation of all the properties along there. One of the interesting aspects of it too is that the actual improved right-of-way of Forest Lawn is actually off-center. Excuse me, the improved street itself is off-center to the west of the actual right-of-way. So in the case of the Henry property, not only do they have the setback of 15 feet to Forest Lawn, but there's additional unimproved distance to the actual street itself or the gravel improvements to Forest Lawn. So basically, I think that's why it's perceived by many of the neighbors to be a less impactful setback reduction due to the alignment of the Forest Lawn improvements. As far as an alternative, basically, if they can't provide a stair there, I think they would no doubt opt to not reduce the size of their deck. So it's what we're trying to do is provide them a reasonable size usable deck as well as a safety improvement in the way of an access stair. So again, if an alternative, a reasonable alternative would be, I guess, considered to just not have a stair in order to retain a reasonable sized deck for the Henry. So again, that is an alternative. It's just a less desirable alternative for the Henrys. And again, there are no other significant impacts to the neighborhood, due in part to the setback offset of the street improvements that I mentioned. And so we hope that you can rule favorably on Henry's behalf. I'm happy to answer any questions.
So when was the house built?
Jeff might be able to answer that. I think it was like the mid 90s.
Yeah, 1993 is, I think, what the assessor's office says.
And
1991.
Okay. So, and what is the square footage of the deck?
I actually have AutoCAD right here.
I mean, when I drove by, it did look like it was very large, and I couldn't quite understand also the stairs from that deck. Was that going to be built on the south side of the house?
No, on the west side.
Okay, on the west side.
Yeah,
So-
the deck is approximately just in the neighborhood of about 11 by 11, something like that. So about 120 square feet.
But getting back to the size of that deck, it looks very small to me. I'm wondering if they've lived with it since that time, why there's such a pressing need to put in a stairwell.
Have they lived in the house the whole
I
time?
don't know.
Well, it's a matter of both convenience and safety, really. They can't put it on the south side due to the side yard setback. So they've opted to put it on the west side where there's certainly more room. If we were to try to put it on the south side, we'd run into fire setback requirements just due to the proximity to the south property line. So the only space for the stair is on the west side.
Okay, are there any other folks, proponents that would like to speak? Are there any opponents that would like to speak? Is there any staff response?
No, I haven't.
Okay, folks, where are you on this project?
To me, it sounds like a reasonable request, particularly for safety purposes, to be able to get out of the house from the second floor.
Yeah, I wish it had been fleshed out a little bit more. I mean, I feel like this application relied mostly on the fact that our neighbors did it, so therefore we should be able to do it, rather than addressing the criteria, particularly criteria F, which I feel is very incomplete. I still don't, I don't see F addressed in this application. And that bothers me because, you know, it's sort of that slippery slope thing. You know, once you approve, I know Joe talks about this a lot, you know, about the idea of side yards, you know, or setback reductions. Are we going, if we approve one, where does it stop? And it's not that I'm necessarily against this particular one. I just wanted to, I'd rather not it rely on the fact that other people did it and rely on the actual criteria as set forth in the ordinance.
Yeah, I mean, you know, it seems to me like they're hopping onto this. We've been lenient on that street to allow for these setbacks to go in. And it's like, it seems like they're hopping onto that request because we've been allowing that. I'm kind of puzzled by the real need for it at this point.
I think the difference is the safety feature. Not being able to get out of the second floor of the house safely is to me the reason why we should accept it.
I mean, there are different ways of approaching that too. In my case, I have a collapsible ladder that you throw over the railing if you need to get off of that. So that versus building, you know, all this stairway thing is to me sort of excessive. So anyways.
I just wish it had been fleshed out a little bit better, the safety issue. I don't, you know, if that's what F is about.
Right. Yeah, I mean, I'm not really sure if, I'm not sure what the elevation difference is from the Hemlock side to the back side on the house. But anyways.
So, would you entertain a continuance for more information on that, Lisa, or?
Yeah, I would, because I feel like, you know, I mean, I think that we have to be really careful with these, you know, setbacks that we have documented all of the criteria and how they fit into the request. And I think that probably won't be difficult to do in this case, but I don't think we should be the ones doing it. I think the applicant needs to set forth why this is, you know, the rehabilitation of the existing building is necessary. I don't think it's up to us to fill in the blanks. I think it has to be in the application.
Yeah, I mean, I agree with you. So are you suggesting then a continuation?
Yes, a continuation just to flesh out all of the criteria, well, the one, F, in the application, to make sure it's complete so we completely understand elevations, safety issues, all that kind of thing.
Okay.
And if in fact there is going to be continuance, do you want written or do you want to come back to a hearing at the next meeting and have an oral presentation?
Well,
I think I would suggest that we just have another hearing.
Yeah, I would agree.
Okay, then this will be continued to our next meeting.
Which is Tuesday, December 21st at 6:00 p.m.
Let's see, do I have any orders to sign?
You do.
I do? Okay.
No.
No, actually, wait, no, we don't have one for zoning.
Yeah. Okay. Okay, then.
Wait, the Harrison?
No,
Oh, no, we're coming back with the findings.
We're coming back with the.
Findings on Thursday.
Yeah. Okay, informational items, any comments on the tree report?
Do we still sign them?
They can do it when they get the.
When they do that, okay.
Ongoing planning items?
Well, the code audit will begin again in January. We expect a report here in the next month or so from them. And then we have the transportation system plan that will move into the preferred alternatives phase in the coming months. And so expect some outreach on that and some more information on that as probably at your next hearing.
Okay. Okay, good of the order. I just wanted to mention that I think everyone of the commissioners should be aware of the fact that there's going to be some big changes this coming year in terms of our members. Both Joe and Charles' second term is up at the end of next month. Janet Patrick's term is up at the end of January of 22. My term is up at the end of April next year. And Lisa, your term is coming up. I believe it's at the end of August. So anyways, I hope you're thinking about people in the community that may want to serve on the board.
Are those all the end of 8 years?
What's that?
Are those all the end of the 8 years, 2 terms?
Charles and Joe's second terms are up at the end of this year.
Okay.
Janice is up at the end of January of 22, so she has a month. And then my term.
But that's 8 years.
That's 8 years.
Okay,
Yeah.
for all of you.
Yes.
Wow, that's big
And-
changes.
Yeah. And the same thing with Lisa and me. Our second terms are up also in this coming year. So anyways, I just want to bring that to everyone's attention. Anything else for the good of the order? Okay, we are adjourned.
Happy Thanksgiving, everybody.
Happy Thanksgiving.
Thanksgiving.
Bye.
Enjoy the turkey.
Thank you all.